Good afternoon, or good morning, or good evening, wherever you are in the world today. I'm Louise Barrington, the director of the Vis East International Commercial Arbitration Moot in Hong Kong. And this is the moment that everyone has been waiting for. 140 teams have been practicing for months. They have gone through at least 4 or 5 arguments to get here. And we are now ready to start the final argument of the competition. With us to judge the final rounds, we have 3 eminent practitioners whom I will briefly introduce before we proceed. First is Dorothee Ruck-Texler. I'm sorry, Dorothee Ruck-Texler, who was a partner at a very large German firm for many years before starting her own boutique arbitration practice a couple of years ago, 2018, and she now practices arbitration and is an alternate member of the ICC Court of Arbitration. Next, we have Dr. Jane Williams, who is a French lawyer with many years, 20 years at least of experience, and has done a lot of work in international arbitration since the beginning. She is an arbitrator on her as a sole practitioner, and also associate professor of law at the Dispute Settlement Program at Tsinghua University in Beijing. She'll be coming to us from France. She is standing in, by the way, for Professor Jeff Weinsheimer, who unfortunately was conflicted out yesterday because he, until recently, taught at Monash University. That's kind of giving things away. Third, in the chair, we have the Deputy Director of the Asian International Arbitration Center, whose rules we're using for this round, and he is Datuk Dr. Prasad Sandosham Abraham. He is a barrister from Middle Temple in London, but practices in Malaysia and has spent his career there, and as I said, is the Deputy Director of the institution whose rules we are using, so he's a very important person. He is the chair of our session today. Now, in this 19th Vis East Moot, the third virtual Vis East Moot, the claimant is El Grupo PLC of Mediterranean, and they are represented by Monash University. The respondent is Jaja Biofuels of Equatoriana, and they are represented by Singapore Management University. So with that, I will pass the floor to the chair, Dr. Prasad, and ask him to take things from here. Thank you.
In relation to contract formation on the 1st of April, we submit that Mr. Chandra, Claimant's Chief Operating Officer, made an offer to his party, Respondent's Head of Contracting, at the Procedural Summit on the 28th of March 2020. This offer satisfies all the requirements and intention to stand. The parties settled the following matters: the goods being RSPO certified cargo, the quantity being 20,000 tonnes per annum for a period of 5 years, and the price being $900 per tonne for the first year and 5% below market price thereat. In addition, Mr. Chandra mentioned 2 ancillary matters for the party: submission of the contract to Mediterranean law, and the application of claimant's general conditions of sale as a matter of company policy. These were the terms of Mr. Chandra's offer. I'll move on then to perhaps the more contentious part of this submission, which is whether this offer was then accepted by Respondent. If I might direct the Tribunal to page 12 of the record. This is This is the email sent by Ms. Bupati to Mr. Chandra 3 days after the Palm Oil Summit. And if I could draw your attention to the indented paragraph about halfway down the page, members of the tribunal, she places an order on the same commercial terms as agreed at the Palm Oil Summit. Pursuant to Article 18, subparagraph 1 of the CISG, this is clear assent to the terms of claimant's offer, therefore an acceptance. Now, we acknowledge that there are some ancillary matters raised in this email. Specifically, in the second last paragraph, Ms. Bupati raises the need to provide for some sort of transparency, for example, applying UNCITRAL's transparency rules. However, this does not preclude contract formation on this date. According to the Graphi Plus case decided in the District Court of Munich, only the necessary minimum elements are necessary to conclude a contract, and parties indicate a clear intent to be bound if they have reached agreement on the price, goods, and quantity. It is immaterial that they may have intended to conclude a more formalised agreement at a later date. Additionally, Ms. Bupati broadly indicates that she is willing to arbitrate, provided provision for transparency and a non-industry specific arbitral institution are provided for. However, taking the respondent's case at its very highest, even if these terms were not finalised on the 1st of April, it is nevertheless our submission that they were all accepted on the 9th of April 2020. If I might direct the tribunal now to page 17 of the record. This is the email sent by Mr. Rain, who is Mr. Chandra's assistant, to Ms. Fokonye, Ms. Bupati's assistant, following the 1st of April email. Ms. Bupati herself is also CC'd into this communication. Now, if I could draw your attention to the end of paragraph 1, members of the tribunal, the final sentence states, "I have inserted the terms of your offer into the contract, which we accept." Pursuant to Article 18, subparagraph 1 of the CISG, this constitutes an unequivocal acceptance. Further, each subsequent paragraph reiterates this acceptance. He attaches the Phosphoporum 81 template referred to by Ms. Bupati with the commercial terms agreed at the summit. He repeats the fact that the contract will be subject to Mediterranean law, which was mentioned in Ms. Bupati's email, and also reminds respondent that the general conditions of sale, which were mentioned at the summit, are applicable to the contract. Now, I'll get to more detail under our submission on incorporation. However, pursuant to the propane gas case decided in the Austrian Supreme Court, a reference during negotiations is sufficient to constitute incorporation of general conditions. The only term which is not explicitly provided for in this email is again that of transparency. In relation to this issue, we make several observations. Firstly, no formalistic adoption of terms is needed in order to constitute an acceptance, and this is pursuant to the commentary of Professor Spaniolo in Professor Mankowski's commentary on the CISG on page 83. Secondly, we note that not only did Mr. Rain not object to the application of transparency to the contract, but also we know from his witness statement that prior to this, he had attempted to apply the UNCITRAL transparency rules to the contract. Unfortunately, he was provided with an inapplicable regime, and he discovered from a friend who was a lawyer that these rules were only applicable to investor-state arbitration. This is reflected in Article 1 of UNCITRAL's transparency rules. Nevertheless, this does not negate the fact that claimant remains happy to apply some sort of transparency to the contract, and this is in accordance with its unequivocal acceptance in the first paragraph of this email. Accordingly, a contract was formed on the 9th of April 2020.
Excuse me, Counsel, if I interrupt there, and thank you very much for drawing our attention to Mr. Rain's witness statement. I'm still struggling with your submission that there was a meeting of minds and a contract was formed. May I please draw your attention to the letter of Ms. Bupati, Ms. Fauconnier on page 30 of the record. And there she writes that there is this issue with the bank, which would be the right one to choose. There are also two other issues where I would suggest changes to the existing. Indicates that there were still open issues and not only ancillary open. The statement of Mr. Rain, he indicates that there was a discussion on whether one could not amend the arbitration rule to the antitrust transparency rules. So it's clear, or wouldn't you agree with me that it is clear that at least at the time when they were discussing that, in early May 2020, the parties had not yet agreed on all issues, be they ancillary or be they important issues.
Madam Arbitrator, firstly I would note that it is the default position under the CISG that only the price, goods and quantity need to be determined in order for there to be a contract. However, even if we assume that these are perhaps more than mere ancillary matters, this email is still consistent with a contract being on foot. Now, to ascertain a respondent's intention here, under Article 8, subparagraph 2 of the CISG, we would look to what would a reasonable person in claimant's position believe respondent's intention was. And we note that Ms. Fauconnier refers to the existing terms of the contract and discusses provision for payment, which may indeed point to an intention to implement the contract rather than there being necessarily issues with banks. Considering the parties' prior communications and claimant's repeated...
Excuse me, if I interrupt you there, she's not referring to the existing terms of contract. She's referring to the existing terms of the contractual documents.
That's correct, Madam Arbitrator, and apologies if I overstated there. However, it is nevertheless our submission that this email is consistent with a contract being on foot and respondents' intention to keep that contract on foot. Indeed, they are taking steps, at least preliminary steps, to perform the contract in relation to the letters of credit. And in relation to the Procedural transparency rules, Ms. Fauconnier later agreed that they were inapplicable and that Ms. Bupati had perhaps only mentioned them because they had been very publicised in the news around transparency in Equatoriana. So, taking all of these factors together, this is still consistent with an intention to implement a contract.
Thank you very much. I have an additional question, and I hope you will bear with me questioning you there. You were saying that according to the CISG, the only important matters to be agreed on are price, etc., etc. You did not mention arbitration and the dispute resolution method. Would you not think that it is very important for us to find jurisdiction in this case, that there is also an agreement on which dispute resolution method to apply?
Madam Arbitrator, I note that I am at 14 minutes. May I take it that the Tribunal will grant me additional time? We acknowledge that while the arbitration arbitration agreements are not mentioned as one of the key elements in Article 14, subparagraph 1 of the CISG. Alterations to them are deemed material under Article 19 of the CISG. And we don't dispute that arbitration is important in the current matter to determine jurisdiction. However, respondents' concerns in this regard not with agreement to arbitrate in and of itself, but rather with implementing some sort of transparency. That is, it was the procedure of the arbitration that was at issue, not arbitration itself. They had already agreed that they would submit to some kind of arbitration, provided transparency was provided for. Since Claimant had no issue with implementing transparency, it is our submission that there are no ongoing issues with dispute resolution. If I might move now to our final submission on when a contract was formed, which is on the 16th of April, we note that this is our only submission on contract formation, which is reliant on established practices pursuant to Article 9 of the CISG. Now, in this scenario, Mr. Rain's 9 April email would constitute the offer, which was then accepted on April 16th via a combination of established practices and conduct. Now, in the previous 40 contracts, which Ms. Bupati concluded in her role at Southern Commodities, Respondent's parent company, she would respond to an offer from Mr. Chandra within a week by either signing the contract, raising objections, or remaining silent but nevertheless performing. Now, here she's done neither of the first two on that list. Therefore, after 3 weeks of silence following this email, it was reasonable for Claimant to assume that she had accepted and that a contract was on foot. Now, we acknowledge the general rule is that silence cannot constitute acceptance under the CISG. However, nevertheless, pursuant to the case of Calzados Magnani in the Grenoble Court of Appeal, silence in combination with an established practice can constitute an acceptance.
There's an important thing, difference here. When these representations of the conduct that you're referring to, she was actually acting on behalf of the principal company, Southern Commodities, correct?
Correct, Mr. Arbitrator.
Now we're dealing with a situation where she is the marketing manager for the subsidiary. So, is it your contention that that conduct that you're relying on in respect of the principal company binds the subsidiary in terms of determining whether there is a contract?
Yes, Mr. Presiding Arbitrator. While we note that this is an unusual commercial situation, we note that not only is Respondent 100% subsidiary of Southern Commodities, but also, in the language of the first April email, it was exercising a high degree of control over the palm oil-based activities within Jar Jar Biofuel. Indeed, Ms. Bupati seemed to be speaking on behalf of Southern Commodities when she said on the 1st of April that Southern Commodities was still committed to the expansion of its palm oil-based biofuel business within Jar Jar Biofuel. Thus, we submit that in these circumstances, where there is close cooperation between the two commercial parties, being Southern Commodities and Respondent, it was reasonable for Claimant to rely on this practice, especially in light of Ms. Bupati's representations.
Is it your position then that the conduct of Ms. Bupati in a role with Southern Commodities as a matter of law can bind the subsidiary? Is that your position?
Yes, Yes, Mr. Presiding Arbitrator, and we draw your attention to the commentary of Professor Mankovsky on the CISG. Now, Mankovsky notes that while the general rule is that practices established between the parties are between the parties to a contract, in circumstances where there is a corporate group with close cooperation between the parent company and its subsidiary, and that it may be appropriate to impute an established practice in that scenario, and that is what we rely on for our submission. I'll move now to our second submission, which is on incorporation of claimant's general conditions of sale. We note that while there is no express provision for incorporation under the CISG, the formation provisions nonetheless govern this question, and this is pursuant to the German machinery case decided in the German Federal Court of Justice and was concretized in CISG Advisory Opinion 13. There are two requirements for incorporation. Firstly, there must be a clear reference, and secondly, there must be a reasonable opportunity to take notice of the standard terms. Now, I've already outlined that there are three clear references on the record: at the Palmer Summit, on the 9th of April, and in the Phosphoporum 81 contract in the preamble. So, the more contentious element then is the reasonable opportunity to take notice. According to paragraph 2.5 of Advisory Opinion 13, there is no general duty to provide standard terms. In these circumstances, we submit that it is appropriate for claimant to rely on respondent having had reasonable opportunity to take notice, as Ms. Bupati had a copy in her previous role at Southern Commodities and had concluded 40 contracts on this basis. In 2016, she was informed of the change to the arbitration clause to the KLRCA model clause, which is now the AIAC, and she was informed of this change and then concluded 8 contracts on the basis of that new clause, the most recent of which was in June 2018. Accordingly, despite respondent itself not having been provided with a copy, we submit that there was a reasonable opportunity to take notice of claimant's standard terms, and therefore they were incorporated into the contract. Unless I can assist the tribunal further, this concludes my submissions.
Thank you very much. Counsel, can you start with you?
Thank you, members of the tribunal. On behalf of the claimant, I will be addressing the procedural matter, and it is our submission that this tribunal does have jurisdiction to decide the substantive dispute between the parties, because the arbitration agreement contained in Article 9 of the General Conditions of Sale was validly incorporated into the underlying contract for the sale of palm oil. I note that my submissions proceed on the basis that we have succeeded on the issue of the underlying contract, as otherwise discussion of the incorporation of a standard term would not be relevant. As a preliminary matter, if I could invite the tribunal to page 32 of the record. The bottom half of this page, reading after changes in 2016, is the arbitration agreement that we submit is binding upon the parties. Relevantly, the second line reads that the seat of this arbitration shall be Danubia, and we acknowledge that at the fourth line, it reads this contract shall be governed by the substantive law of Danubia. If I can invite the tribunal to turn back to page 17 of the record. At the end of the second paragraph, it relevantly reads, the sale will be governed by the law of Mediterraneo. Thus, on the issue of the law of the underlying contract, this has been a point of express negotiation between the parties, and under clarification 33 of the record, it is agreed between them that the law underlying the contract is that of Mediterranean. Thus, given that there appears to be no express choice of law for the arbitration agreement, it is necessary to determine its proper law to apply the rules of incorporation of standard terms to answer this ultimate question of whether that arbitration clause has been incorporated into this underlying contract to consequently confer jurisdiction. On our present facts, there are two competing jurisdictions that may ultimately govern this issue. On the one hand, there is the law of Danubia, being the law of the seat, under which there is a singular requirement of a clear reference in order to incorporate standard terms. On the other hand, there is the law of Mediterranean, being the law of the underlying contract, under which either the CISG may apply, or the Mediterranean civil law, being an adoption of the UNIDROIT principles. And it is our submission that under the latter, there is that same singular requirement of a clear reference that is necessary in order to incorporate standard terms. If I may then turn to my first submission, which is that the law of Danubia governs this arbitration agreement. The starting point for this tribunal is at Rule 13.5a of the AIAC rules, which states that the law governing this arbitration agreement will be what the parties have agreed, and in the absence of choice, this tribunal has a discretion to determine that proper law. If I may briefly address the issue of this tribunal's discretion in the absence of choice, we submit that that discretion ought to be exercised consistently with the positions of both Danubia and Mediterranean being the two relevant jurisdictions on the record, and under clarification 32, both jurisdictions have domestically resolved this issue in accordance with the rule contained in Article 5.1a of the New York Convention. Now, whilst I note that
Just 1 minute, so can you point out the specific rule in the AIAC rules that allows this tribunal to decide on the question of the proper, whether there is a proper arbitration clause, which is a proper law that be applied, the seat, all these issues, criminal issues. Under what rule do you move the tribunal to decide? The AIAC rules.
yes, Mr. Arbitrator, it is Rule 13.5a of the 2021 AIAC rules, which governs the issue of the proper law of the arbitration agreement. Thus, in the issue of this tribunal's discretion, as I indicated, it ought to be exercised consistently with the rule contained in Article 5.1a of the New York Convention, which relevantly states that in the absence of choice, there is a default rule in favour of the law of the seat. Now, whilst I acknowledge that the New York Convention itself is aimed at the enforcement stage of the proceedings, the fact that the two relevant jurisdictions have domestically resolved their choice of laws analysis in this way makes it directly applicable to the present stage. And thus, there is a three-step test for this tribunal in its choice of laws analysis, asking firstly whether there has been an express choice of law, second, whether there has been an implied choice, and third, in the absence of choice, there is that default rule in favour of the seat.
Well, I have a question here, because if we do apply the rules you mentioned under Article 13.5a, it doesn't refer to choice implied or express. It refers to an agreement. And why should we apply a three-step process when actually the rules do not require us to do it?
Yes, Madam Arbitrator, I acknowledge that the relevant term in the rules is that of agreement, but it is widely understood that agreement and choice can be synonymous, and within that there are notions of both express and implied choices. But ultimately nothing turns on the distinction, because it is our position that there was simply no choice of law for this arbitration agreement, and so we should turn instead to that default rule in favour of the law of the seat. Whilst there appears to be no express choice of law, where the parties diverge on the present case is on the existence of an implied choice of law. It is our understanding that the respondent may argue that by virtue of the parties having selected a law for their underlying contract, that this constitutes an implied choice of law for the arbitration agreement. they may cite cases such as that of Enka and Chubb, handed down by the UK Supreme Court in 2020. And indeed, we acknowledge that in paragraph 53 of that decision, their lordships do state that there is a presumption that where parties select a law for their contract, that this choice does extend to arbitration agreements. We generally agree with the premise of Enka and Chubb, which is that in ascertaining party choice, and indeed implied choices, that this is a process of contractual interpretation. However, this process of contractual interpretation must be rooted in ascertaining the actual and subjective intention of the parties, rather than utilizing presumptions or inferences, which are ultimately mere guesses as to what the parties may have thought had they turned their minds to the issue. Indeed, an implied choice must therefore be one that is rooted in the record, through the language, the conduct, and the circumstances of the parties. Even taking these presumptions at their highest, they are ultimately mere placeholders for the real exercise of contractual interpretation. And an example of this would be in the 2016 decision of BCY and BCZ, handed down by the Singaporean High Court and approved in the subsequent decision of BNA and BNB in 2019. Now, we acknowledge that in that decision, Justice Chong also began with that presumption, which was originated in the Sula America decision. However, he then proceeded to interpret the clause made by the parties, and the relevant choice of law clause in that decision read, "This agreement shall be governed by the laws of New York," where the term agreement was capitalized and defined to read all clauses in the contract. And so, by process of interpreting that contract, Justice Chong arrived at the conclusion that the parties had impliedly chosen the law of New York to also govern their arbitration agreement. By contrast, no such evidence exists on our record to reflect an understanding that the parties had actively and actually turned their minds to the issue of a governing law for their arbitration agreement. Indeed, when discussing the choice of law for the contract, they interchangeably used the terms contract, sales contract, and even just the sale, as can be seen on page 17 at the end of that second paragraph. This is limiting and narrow language, and does not evince any understanding by the parties that they had understood the need to separately turn their minds to a governing law for their arbitration agreement. Whilst we can make our case on these common law authorities that the respondent may cite, ultimately they should place lesser weight, because the two relevant jurisdictions, being Danubia and Mediterraneo, are civil law jurisdictions, as can be found at clarification 36 of the record. And so if we then instead turn to comparative civil law instruments, for example, the Rome I regulations, which is widely understood as a codification of the civil law position, states in Article 3 that an implied choice must be one that is clearly demonstrated from the circumstances. In addition, the Hague Principles on the choice of laws at Article 4 states that a tacit choice must appear clearly from the record. Now, whilst we acknowledge that these instruments do not directly apply to arbitration agreements, they are useful in understanding a comparative approach by civil law jurisdictions in interpreting contracts and indeed implied choices. And so what is common between all the authorities is that this is a process of contractual interpretation rooted in understanding subjective and actual intentions, and indeed one does not exist on this record. This is in line with commercial reality, which is to say that arbitration agreements are often referred to as midnight clauses for the very reason that they are forgotten until the last minute. And so if this tribunal does find that no choice was made, then that default rule under Article 5.1a of the New York Convention ought to be triggered, applying the law of the seat, being Danubian law, as the proper law for this arbitration agreement. As I earlier prefaced, I've noted I'm at 11 minutes. Is that also the reading of this tribunal? Thank you. Applying Danubian law, as I earlier prefaced, there is that singular requirement of a clear reference. That is all that is necessary to incorporate standard terms, And as Ms. Rafe earlier stated, there were at least 3 clear references on the record that would be successful to incorporate this arbitration agreement into the underlying contract. However, and in the alternative, if this tribunal does apply Mediterranean law to this arbitration agreement, then we would make 2 submissions. The first is that the CISG ought not apply to arbitration agreements, and then the second is, by consequence, the Mediterranean civil law, being an adoption of the unidroit principles, should be the appropriate standard. Turning to the first issue of the CISG's non-applicability, it is widely understood that arbitration agreements are separable from an underlying contract, as enshrined under Rule 20.1 of the AIAC rules, as well as Article 16 of the model law, in this case being that of the Danubian arbitration law. Counsel for the respondent may take you to the 2 mentions of dispute settlement clauses in the CISG, being at Article 19.3 and Article 81. However, if we turn to the travaux préparatoire of the CISG, we can see that mentions of these in both those articles were not intended to somehow indirectly expand the CISG's application to arbitration agreements. The reason for why settlement dispute clauses are mentioned in Article 19.3 was to give some concreteness and uniformity to the definition of what is material in the context of an Article 19 counteroffer, and it cannot be said that this would somehow regulate the effectiveness or conclusion of arbitration agreements in the course of that definition. In addition, Article 81 is widely understood as a codification of the doctrine of severability, and again, that cannot work to somehow get the CISG to regulate arbitration agreements. Even if we isolate just the formation provisions of the CISG alone, this would still prove to be a dysfunctional regime for arbitration agreements. For example, Article 14 defines a sufficiently definite offer as one that includes price, goods, and quantity, but this would be inapplicable to an arbitration agreement, which is inherently an exchange of promises to arbitrate instead of litigate. And so where this tribunal does have discretion to determine the proper law, and indeed is seized with a more appropriate framework through the unidroit principles under Mediterranean civil law, this should instead be the preferred standard to govern this issue. And it is our position that under the unidroit principles, there exists that same singular requirement for a clear reference, that is all that is necessary to incorporate standard terms. There is no express requirement at Article 2.1.19 of the principles for there to be a reasonable opportunity to take notice. Indeed, all that is stated is that the standard rules of formation apply. Further, at Comment 1 under Article 2.1.20, it says that acceptance includes parties being bound irrespective of whether or not the counterparty actually knows of the contents of the general conditions. Thus, we should not read into this an additional requirement beyond that of needing to exchange surprising terms. And again, for under the same reasons as under the Danubian law, the 3 clear references would be enough to incorporate the standard term. I further note that counsel for the respondent may raise the exception to this rule, being those of surprising terms, but it is our submission that this arbitration agreement is not the same. Under Article 2.1.21, or the equivalent provisions under the CISG, a surprising term is one that the other party could not have reasonably expected. However, the arbitration clause, as enshrined in Article 9, is indeed a reflection of the parties' negotiations, containing a non-industry specific institution, which is what Ms. Bukati requested on the 1st of April, and some sort of transparency through the derogable positions under the AIAC rules regarding confidentiality and the publication of awards. I thank the Tribunal for its extension of time, and unless there are any further questions, I will conclude my submissions there.
Thank you, Counsel. I do have one additional question, if I may, Mr. President. You were just saying that this is not a surprising clause. Now, wouldn't it be completely counterintuitive that the arbitration clause would be ruled by Danubian law, whereas the whole contract would be governed by the law of Mediterranean? I do struggle with this. I realize that intuition is not a legal aspect, but when you are referring to what the parties have agreed on and whether they would be surprised, this turns out to be a legal concept. So I'm really struggling with your submission that Danubian law should be applicable in this case for the
Madam Arbitrator, I apologise for the inconvenience, but we'd actually just dropped out of the Zoom call due to a lapse in our internet connection. Would you mind repeating the question?
Yes, of course. Did you hear the beginning of the clause?
Unfortunately not, we had dropped out.
Okay, I'm sorry for that. I will, of course, repeat. You were just saying at the end of your argument that the arbitration clause was not a surprising clause and would therefore not would therefore be included. And I was saying that I struggled with that because to me, applying Danubian law to the arbitration clause or the question of the validity of the arbitration clause is completely counterintuitive because the parties were talking about the law of Mediterranean all the time. And I was wondering, I'm sure that, or I know that intuition is not a legal concept, but when we're talking about surprising or not surprising, I'm struggling with that because the law of Danubia has never been mentioned to Respondent, and they haven't received a copy of the general terms. So how can you say that the application of Danubian law is not surprising?
Thank you for your question, Madam Arbitrator. I will note firstly that in the context of the choice of laws analysis, we apply the law of Danubia as the law of the seat, not because the parties chose it, but because the parties had made no choice at all. Indeed, that is the relevance of the default rule, which respects that where parties have simply not turned their minds to the issue, the seat is the most appropriate law in that instance. As to Ms. Bupati's knowledge of this seat, indeed, the seat of Danubia has been regularly used between the contract exchanges of Ms. Bupati and Mr. Chandra in the course of their relationship throughout the history, and indeed the last 8 contracts between Ms. Bupati in her time at Southern Commodities and Mr. Chandra. Now, whilst this invites the same issues as what Ms. Rafe had raised as to the ability to impute Ms. Bupati's transactions in her time at Southern Commodities, it is ultimately not relevant to this issue in the choice of laws analysis, because even if this tribunal does find that in fact a seat was not communicated, then we can still arrive to Danubia being the relevant seat by virtue of Rule 14 of the AIAC rules and Article 20 of the Model Law, both of which provide that the seat should either, in the AIAC rules, the seat either being Kuala Lumpur or the seat that is most appropriate. Danubia, in any instance, would still be the most appropriate seat due to its neutrality as compared to the other jurisdictions on this record where either party does have a relevant stake, Mediterranean being the place of the claimant, Equatoriana being the place of the respondent, and Mauritania being the place of Southern Commodities. Thus, whether or not Danubia as the seat was ultimately communicated has no bearing on the choice of laws analysis, because it is not necessary for the parties to have chosen the seat of Danubia for Danubian laws to still apply by virtue of the default rule.
Thank you very much.
We proceed to the counsel for the response. Don't worry, we'll afford you the same indulgence in time. Just present your case. Alright? Thank you.
Thank you, Mr. Presiding Arbitrator. Members of the Tribunal, a very good afternoon from Singapore. My name is Dawn Wee, and I will be presenting the merits of the case on behalf of the respondent. With me today is my co-counsel, Ms. Elizabeth Wee, who will be presenting the jurisdictional issues on behalf of the respondent. Now, members of the Tribunal, Claimant has just lost one of its long-term major customers, leaving it with a large supply of palm oil to sell off at short notice. It is against this backdrop that Claimant seeks to force my client to fill these shoes. Opposing counsel earlier pointed this tribunal to a course of conduct between Mr. Chandra and Ms. Bupati, arguing that a contract could have been formed at various stages of parties' discussion. What the claimant seeks to downplay is that the parties were at all times still in the process of pre-contractual negotiations, which never amounted to a formed contract. On top of this, the claimant seeks to unilaterally impose its own set of general conditions on my client, ignoring the fact that it has never once sent these terms over to the respondent. With this, I will make two main submissions today. First, that there was no contract between the parties, and second, that even if a contract was formed, this simply did not include claimant's set of general conditions. Now, turning to the first issue of contract formation, first as a preliminary point on the law, opposing counsel for claimant has argued, and I quote, that only a stipulation of the price, goods, and quantity are needed for a contract. Members of the tribunal, this is simply not what's stated in the CISG. And allow me to quote from Article 14, subsection 1. Not only must the offer be sufficiently definite, it must also, and I quote, indicate the intention of the offeror to be bound. Now, members of the tribunal, while the terms were indeed definite, at no point was there a binding intention to be bound to an offer. With this, I turn to the first date that was raised by the claimant, which is at the Palm Oil Summit. Now, claimant argues that there was an offer made at the Palm Oil Summit. Unfortunately, this contradicts their pleadings in the notice of arbitration. If this tribunal would turn with me to page 5 of the record, and if they may confirm that the tribunal is free. Thank you. Thank you. Particularly at the 5th paragraph, it states, and I quote, thus, it was agreed that Ms. Bupati, on behalf of the respondent, would get back to Mr. Chandra with a definitive offer within the next 3 days. So there was no offer made at the Palm Oil Summit, and the reason for this is also explained at the 5th paragraph. On top of the line that I just quoted for this tribunal, it states that Ms. Bupati wanted to get approval from the management first before entering into any contract with the claimant. Now, members of the tribunal, for these reasons, there was no offer made at the Palm Oil Summit because parties did not.
I have one question here because it seems that your witness, Ms. Bupati, on her witness statement at the very end on page 31, states that she made an offer at the summit.
Well, Dr. Williams, certainly. However, we party acceptance in a loose sense rather than in a legally binding sense. In fact, this tribunal can confirm this fact by looking to the 3rd paragraph on page 31. So if this tribunal will look there, it states, with Mr. Chandra, I had established a practice that if the terms of my offer were acceptable, that he would prepare the contractual documents and send them to me for acceptance. So legally, it is not possible for a party to both make the offer and later accept the same offer itself. And therefore, Ms. Bupati was merely speaking in the commercial sense of the word and not the legal sense of the word offer here. Now, we turn to the next instance that the claimant has raised, which is that there was an acceptance at page 12 of the email. However, if the tribunal is convinced that there was no original offer made, then there could simply have been no acceptance. Rather, what Ms. Bupati did do here is to get back to the claimant with an offer. So to clarify the position once again, we agree that the email on page 12 was an offer. However, what we would like to clarify and bring to this tribunal's attention is that at the 5th and the 6th paragraph, Ms. Bupati had evinced her discomfort with the idea of arbitration, and the reason why can be found at the 6th paragraph, where she states that she is facing strong opposition of several of the most influential activist groups to arbitration. So we would implore the tribunal to keep this in mind as we turn to the next page, which is page 17 of the record. Now, if I may confirm that the tribunal is with me on page 17.
I think your point that you're making is parties are loosely using terms, but we have to interpret it from a legal standpoint. So there has to be a definite offer, a definite acceptance by their conduct, not so much of the words they use. Am I correct? But when you look at that whole letter, the whole email, the language suggests a contract, an offer, an acceptance, and there's only a question of implementation, sorting out the minor details. The consensus at item has already been reached. Would you agree with that, Councillor?
Mr. Presiding Arbitrator, with respect, we would not agree with the fact that parties had a consensus or a meeting of the minds as to a contract that was being formed. Rather, we do agree that there was definitive wording on page 12 and that Ms. Bupati was making an offer. So Mr. Presiding Arbitrator was absolutely right to point out that Ms. Bupati did, through her conduct, evince that she was making an offer. However, the point is that a contract was still not concluded because this offer was not accepted by the claimant. As such, there was no consensus in this sense. Now, earlier, opposing counsel argued that the acceptance was found at page 17 of the record, and if this tribunal is with me on page 17.
Yes.
So, to quote opposing counsel directly, they state that because the terms in the first paragraph stated which we accept, that this gave rise to a binding offer. Now, in fact, they went further to say that every subsequent paragraph confirmed the acceptance of the contract. However, we would emphasize to this tribunal that at the 3rd paragraph, claimant states, claimant's general conditions of sale apply to issues not regulated in the attached document. So what the claimant has attempted to do here is to insert a whole new set of terms in this purported acceptance. Members of the tribunal, the law on this point in the CISG is clear. Article 19, Section 3 of the CISG states that a reply to an offer, which includes a dispute resolution clause, renders it as a rejection of the original offer, and it is instead a counter offer. Now, this is even more so the case on our present facts. As I pointed to this tribunal earlier, there were concerns regarding the arbitration clause raised by the respondent in its offer email. What the claimant has sought to do here is to take the choice of an arbitration clause out of the respondent's hands, but simply impose what they feel would be a suitable arbitration clause. In such a situation, the rationale behind Article 19 becomes particularly important. The respondent should be given a chance to decide if it wishes to accept the arbitration clause that the claimant proposes. The claimant cannot simply assert that because there was an addition here that had somehow been agreed on between the parties, that this is not a counter-offer. As such, as the law stands, the email on page 17 was a counter-offer and not an acceptance because of the addition of the general conditions. Now, to take this argument all the way to the end, claimant asserts that there was an eventual acceptance of this counter-offer by way of conduct. Now, in response to a question posed by Mr. Presiding Arbitrator, the opposing counsel argued that practices established between respondent's parent company and the claimant could be attributed to the respondent itself. unfortunately, members of the tribunal, once again, this is simply not what the law provides for. In fact, Professor Schwenzer has noted in her CISG commentary that only practices between the same parties matter, and practice cannot be established without any preceding business contact. And the fact here is that respondent and claimant have never once contracted with each other. As such, it would be unfairly onerous to impose these prior practices established with a separate legal entity onto the respondent itself. Now, once again, Dr. Williams, did you have a question?
Yes, you saw me moving. My question is, those were the words used by the claimant that Ms. Bupati was informed about the content of the general conditions, and should we draw any consequence of this as to the practice of the parties?
Well, Dr. Williams, we do not dispute that Ms. Bupati was informed of the terms of the general conditions. However, we must keep in mind that this was only conveyed to Ms. Bupati via a single phone call made 4 years ago while Ms. Bupati was working for the parent company and not for the respondent itself. As such, it might not have been fully reasonable for the claimant to expect that Ms. Bupati would remember the contents of such a phone call. And in fact, Bupati did evince from her email on page 12 that she had forgotten about the phone call was originally made in the year of 2016. Now, this is demonstrated on page 12 of the record, if this tribunal would turn there. Now, at the last line of the 5th paragraph, it states, and I quote, "In particular, if we submit to an institution which deals exclusively with palm oil." Now, to give this tribunal some context, claimant has had 2 sets of general conditions. The older set provided for arbitration under the phosphor or PORAM clause, which is an industry-specific clause, whereas the current general conditions provide for arbitration under the AIAC, which is a non-industry-specific clause. The respondent, in mentioning its problems with the industry-specific clause, conveyed her misunderstanding that the older set of the general conditions was to apply. And now that claimant seeks to impose the new set of general conditions, this does not exactly match the knowledge in these 2 cases. And in fact, Dr. Williams, this brings me nicely to my second submission. Because Ms. Bupati did not know of the actual terms of the general conditions, it cannot be said that she had a reasonable opportunity to take notice of the contents of the terms. And this is in fact furthered if the tribunal would look to page 17 of the record. Now, what we see at page 17 is the way that the claimant responded after knowing about Ms. Bupati's misunderstanding. If this tribunal would look through the wording of page 17, claimant makes no attempt to correct Ms. Bupati's wrong impression. Instead, what they do state at the 1st paragraph is that, as Ms. Bupati expected, the template used is the customized and shortened version of the phosphor PORAM 81 form. And members of the tribunal, this phosphor PORAM form precisely provides for arbitration under phosphor or PORAM and not under the AIAC, as the claimant currently seeks to provide for. As such, not only has the claimant failed to correct Ms. Bupati's wrong understanding, they have in fact confirmed her misunderstanding that the older general condition and not the new general conditions that were to apply. For these reasons, this cannot amount to a reasonable opportunity to take notice of the standard terms. Now, members of the tribunal.
Excuse me, counsel, if I interrupt there, would you not think that the recipient of general terms that does not know the general terms would have a duty to inquire about the general terms?
Dr. Teschler, Under CISG Advisory Council Opinion number 13, it states clearly that the duty is not on the receiving party to ask about the standard terms. The duty is instead on the party seeking to impose the terms to make it available to the counterparty. And this is because of the principle of good faith, which is provided for under Article 7.1 of the CISG. Members of this tribunal can imagine that it would be far easier for the claimant to just have attached a copy of the general conditions, rather than requiring the respondent to make the active step to inquire about the applicable terms. As a result, the respondent was not under a duty to inquire, but rather the claimant was under a duty to provide these general conditions. As such, the general...
I do not disagree that claimant had a duty to inform respondent about the general terms, but applying the good faith test, I wonder whether in this particular situation it would not have also been respondent's obligation to inquire about the general terms.
Dr. Vukteshla, certainly it would have been much easier for the present circumstance if Ms. Bupati actually asked about the terms of the general conditions. However, the reason why she did not ask is because she assumed that the previous set, which is the 2011 set, would also presently be in force. And the test, the legal test, is whether or not she had an opportunity to know of the correct terms of the general conditions. And because claimant did not correct her misimpression, but rather went on to confirm this misunderstanding, we say that this simply cannot amount to a reasonable opportunity for Ms. Bupati to have known of the terms of the general conditions. As a result, to conclude my submissions for today, first, there was no contract formed as between the claimant and the respondent, and second, the general conditions cannot be incorporated into any contract at all. Now, unless I need any further assistance to this tribunal.
I want to ask one question. It actually flows from this thing of good faith and what Dorothy asked you. We have a situation here where that letter on page 17 is the assumption of acceptance of contract, and the contract is in place, right? Then the next thing that happens is the termination. Am I correct, counsel? Right?
Yes,
So in between all that period of time, because the termination letter talks about negotiations, in that period of time, is it your position that there was no consensus? Having a look at all these letters, is that your position?
Mr. Presiding Arbitrator, it is exactly our position that there was no consensus as to the formation of the contract. This is because, as provided in Article 18, subsection 1 of the CISG, silence cannot amount to an acceptance of the contract. Now, what opposing counsel did earlier raise, instances of acceptance via silence, this was only as between Southern Commodities and the claimant, and not as between the respondent and the claimant itself. As a result, it would be unfairly onerous to pin this burden more on the respondent, given that it had never once contracted with the claimant before. As a result, non-objection in this case cannot amount to acceptance of any contract. I hope that answers your question, Mr. President. Thank you.
All right. Elizabeth?
Members of the Tribunal, a very good afternoon from Singapore. I'm Elizabeth Wee, and I continue the case for Respondent on the jurisdictional issues. Despite the concerns that my client raised to arbitration, Claimant now insists that parties agreed to arbitrate on the basis of its arbitration clause within its general conditions. However, if the tribunal agrees with my co-counsel that no contract was formed, then it does not have jurisdiction, as there is simply no contract for the arbitration clause to be incorporated into. Assuming a contract exists, my co-counsel has argued that incorporation fails under the CISG because claimant has never made the terms reasonably available to respondent. Now, claimant seeks to bypass this requirement under the CISG by arguing that the arbitration clause alone is governed by Danubian law, which does not have this requirement. However, Danubian law is simply not the proper governing law of the arbitration clause. Instead, my submissions will show the tribunal that first, Mediterranean law is the proper governing law of the arbitration clause. Second, since Mediterranean law applies, the CISG is also applicable to the arbitration clause, in which case there is a requirement to make the terms reasonably available that has not been fulfilled on the facts. If time permits, I will also respond to claimant's alternative argument that even applying the Danubian law or Mediterranean law excluding the CISG, claimant's arbitration clause is still of no legal effect because it was surprising to respondent. Thus, respectfully, this tribunal lacks the jurisdiction to hear the present dispute. Now beginning with my first submission, the heart of this issue is whether the law of the seat, Danubian law, or the law of the contract, Mediterranean law, that governs the incorporation of claimant's arbitration clause. We agree with opposing counsel that here, parties have not made an express choice of law, and the tribunal is guided by both Rule 13.5 of the AIAC rules as well as Article 5 of the New York Convention, which has been interpreted to encompass a three-stage test. However, we disagree with opposing counsel that parties had not made an implied choice of law. Instead, we argue that by choosing Mediterranean law as the law for the contract, they have also made an implied choice that this law governs the arbitration clause. This is for three reasons. First, case precedent. Second, parties' intention and commercial expectation. And third, as a matter of principle. First, as a matter of authority, opposing counsel has cited some common law jurisdictions in arguing that there is a presumption for the underlying contract to apply, and they have also cited some civil law jurisdictions in arguing that the law of the seat is favored to apply. We fully recognize that this issue of implied choice is an unsettled one. However, we submit that both common law and civil law jurisdictions have taken this approach favoring the contract law over the law of the seat. This was the position taken in the 2020 case of Enka and Chubb by the UK Supreme Court, as well as the German Federal Court in the decision of 28 November 1963, as well as the Tokyo District Court in the judgment of 28 August 2007. So we see that there is widespread authority across both common law and civil law jurisdictions for the law of the contract to apply. Now, to demonstrate this implied choice on the facts, here if the tribunal would turn with me to page 12 of the record. May I check that the tribunal is with me? Thank you. At the fifth paragraph, the tribunal will see respondent confirming that the sales contract will be submitted to Mediterranean law. This choice was subsequently confirmed by claimant in their responding email found on page 17, and to quote for the tribunal's ease of reference at paragraph 2, the sale will be governed by the law of Mediterranean. So we see that here, in this present case, parties have made an express choice of law for Mediterranean law as the law of the contract. Here, this brings me to the matter of principle and commercial sensibilities. As the UK Supreme Court has explained, when parties choose a system of law for their contract, they expect for this system of law to encompass all matters related to their legal relationship, and this presumption is not rebutted simply by the choice of seat, especially since here, parties have expressly discussed the choice of law of Mediterranean law, whereas no such discussion was had for Danubian law. The tribunal will see the only reference to Danubian law as the law of the seat within Claimant's arbitration clause itself. There, this was a choice, we must emphasize, made by Claimant itself, and this was not at any time communicated to Respondent in the course of this contractual negotiations. And as Dr. Procedural has earlier commented on, parties do not see, it would be counterintuitive for parties to think that a different law would govern their main contract and a different law to govern the arbitration clause. Instead, parties see their contract as a whole contract, including the arbitration clause, and they do not divide their choice of law, especially such a general choice of law here, within the sales contract and the rest of the arbitration clause. Here, at this juncture, I note opposing counsel's argument that an arbitration clause is a midnight clause, thus parties can be presumed not to have directed their minds to the applicable law of this clause unless expressly stated. However, what we stress here is that the dispute resolution mechanism was at the forefront of parties' discussions. This was the main obstruction the respondent had towards accepting the contract. In the very same breath that they talk about the choice of law in both the emails on page 12 and page 17, they also discuss the arbitration clause, and they must, as a matter of commercial expectations, have intended the law governing the contract to also govern the arbitration clause. Thus, the proper governing law of the arbitration clause here,
I have a question. Sorry, go ahead.
Please.
Thank you. The Claimant has drawn our attention to the different wording under 12, 17, and the arbitration agreement to either sales contract, sales or contract, and has referred to Singapore case law that referred to the agreement with capital A. So how should we construe the clause, and does it make a difference with the wording that is used by the parties? What's your view?
Dr. Williams, we say that here, parties have not intended to distinguish between contract with a capital C and sales contract with no capital letter, and that this is in fact distinguishable from the Singapore case that they cited. And to substantiate this point, here I refer the tribunal to Claimant's own notice of arbitration, which can be found on page 5 of the record. There at paragraph 7, near the middle of that paragraph, here Claimant has explained that the contract with capital C will be governed by the law of Mediterranean. Here we note two things. That the correspondence on page 12 and page 17 were drafted by commercial parties who would not have known of the distinction between a contract and a sales contract. What's more is that the notice of arbitration drafted precisely by Claimant's lawyers did not make a distinction between contract and sales contract, and in fact referred to contract with a capital C when they talked about the change to the law of Mediterranean. So we see a consistent intention here for the sales contract, including the arbitration clause, to be governed by the law of Mediterranean. Now, Mr. Presiding Arbitrator, may I assist with your query?
I didn't have any. I just noticed Jane raising hands. Sorry, please go ahead.
Now, having argued that Mediterranean law is the proper governing law of this contract here, we argue that the CISG is also applicable to the arbitration clause. Preliminarily here, both Claimant and Respondent originate in countries which are contracting states of the CISG. Thus, under Article 1, subsection 1 of the Convention, the CISG is applicable to the sales contract. Here, in fact, the Tribunal has heard from both speakers and merits that they agree for the CISG to apply to contract formation and the incorporation of Claimant's general conditions as a whole. Thus, it is our position that it is only logical for the same law to govern also the incorporation of Claimant's arbitration clause, which is part of the general conditions of sale. To suggest otherwise would be unnecessarily complicated and artificial. Furthermore, this approach that the CISG can govern arbitration clauses is taken by many case authorities as well as is confirmed on the express wording of the CISG. First, as a matter of case precedent, this approach of applying the CISG to the arbitration clause has been taken by the German Federal Supreme Court in the recent 2020 case of Mayflower and dating as far back as the US District Court in the 1992 case Orlando and Talwich. So we see that there is precedence for applying the CISG to arbitration clauses, and the principles underlying these decisions are simple. The CISG was intended to apply to contracts of sales of goods, including arbitration clauses. This can be confirmed on the express language of the CISG. Here, important is Part 1, Chapter 1 of the CISG, which sets out its scope of application. Article 4 states that this convention governs the formation of the contract of sale and the rights and obligations of the seller and buyer arising from such a contract. Although we recognize the separability principle, which insulates the validity of an arbitration clause in the event that the validity of the main contract is challenged, here we see that the separability principle does not insulate the arbitration clause for the purpose of deciding if the CISG applies. Instead, to quote the UK Supreme Court in Anchor and Chap, the arbitration clause is part of the bundle of rights and obligations recorded in the contractual documents. This must mean that the CISG also applies to arbitration clauses which are part of this contract of sale. Here, opposing counsel has relied on two further articles of the CISG, claiming that they do not bring dispute resolution clauses within the scope of the CISG. Particularly, they have cited Articles 19.3 of the CISG and Article 81. However, both these articles buttress our position that the CISG applies to arbitration clauses. First, Article 19.3, as the Tribunal has heard, provides that the addition of an arbitration clause in an acceptance would be a material alteration of the acceptance and renders it a counteroffer. This is only sensible if the dispute resolution clause were considered a term of the main contract, and thus it falls within the purview of the CISG. The same can be seen reflected in Article 81. Article 81 states that the avoidance of a contract does not affect any provision of the contract for the settlement of disputes. Now, as Professor Spencer has noted, the CISG cannot preserve the validity of an arbitration clause if it did not also govern that clause and apply to that clause. This must mean that arbitration clauses are considered part of a contract of sale for the purpose of applying the CISG. Thus, the proper governing law of the arbitration clause here is Mediterranean law, including the CISG. Now, to summarize this argument, my opposing counsel has argued that applying the CISG, the arbitration clause is not incorporated because claimant never made the terms reasonably available to my client. Thus, under the proper governing law, the arbitration clause has not been incorporated, and the tribunal does not have the jurisdiction to hear the present dispute.
Ladies,
now I note that my time has elapsed. However, if I may have 2 additional minutes to address opposing counsel's argument on this surprising term. Thank you very much. Opposing counsel has argued that here, claimant's arbitration clause is not surprising to respondent because it meets the request of a non-industry specific arbitration institution, and second, for some sort of transparency rules. However, as Dr. Scheller has pointed out, here the arbitration clause contains the seat of Danubia, which was at no point in time communicated to respondent. Furthermore, we see that respondent's intention was at all times to discuss the arbitration clause with claimant and not to agree to arbitration at any cost. This can be seen from page 10 of the record, which reflects Mr. Chandra's witness statement at paragraph 11, where at the second last line, we see that at the Palm Oil Summit, Ms. Bupati had informed Mr. Chandra that it may be necessary to adapt the dispute resolution mechanism given the widespread hostility to arbitration in their home country. These concerns were further elaborated in Respondent's email to Claimant on page 12, where they state, and I quote, "At least we should select for some sort of non-industry related arbitration institution and transparency rules." Clearly, what they had wanted was for a discussion and for a selection by both parties of the arbitration clause. What Claimant did, however, was to take this choice and the opportunity to decide from Respondent and to instead unilaterally impose this term on Respondent without telling them of the contents of the arbitration clause. Thus, even if the arbitration clause was incorporated, it is not binding on the parties because it was surprising to Respondent. To conclude, for these reasons, we ask the Tribunal to find that it does not have jurisdiction to hear the present dispute and that no contract was formed in any case. Unless I may be of further assistance to the Tribunal, this concludes my submissions. Thank you.
Thank you very much, Elizabeth. Councillors for the claimant, your quick answer, submission, button.
As a matter of procedure, Mr. Presiding Arbitrator, is the Tribunal amenable to us responding separately on the merits of the procedure? Or would you like the reply to be given by one speaker?
Okay, you can reply by one speakers. I think that will be fine. Alright? But you got to thank the statement, just by that.
Thank you.
Thank you.
Thank you. Opposing counsel stated in relation to the incorporation issue that Claimant purported to incorporate a new set of terms, being Claimant's post-2016 general conditions of sale on the 9th of April, and therefore this was a counteroffer and not an acceptance. However, if Respondent's position is that this is an entirely new contractual relationship, it does not follow that Claimant would be using an old set of terms which had not been enforced for 4 years. However, in relation to Ms. Bupati having forgotten about the terms, this was not evident to Respondent. Clarification 11 of the record shows that it is standard practice in the palm oil industry to use industry-specific arbitration institutions. Thus, it was at least open to a reasonable person in Respondent's position to think that Ms. Bupati was merely clarifying in relation to the trade usage. Therefore, the 9 April email is not a counteroffer.
Would the Tribunal prefer for me to go next?
Yes.
Thank you, members of the Tribunal. With regard to the procedural issue, I note that counsel for the Respondent stated that the parties had not intended to distinguish between their contract and their arbitration agreement, and subsequently attempted on that basis to distinguish the Singaporean authority that I had raised of BCY by stating that rather these are simply commercial non-lawyer parties. That is precisely the point. It was the standard of parties who had drafted their contract in accordance with the laws in BCY that met the threshold of implied intention, given that that is the kind of drafting necessary to demonstrate an implied intention. By contrast, counsel for the Respondent did not point to any contemporaneous evidence on the record to demonstrate that the parties had actually understood the notion for the governing law of their arbitration agreement, whether express or implied. Thank you.
Members of the Tribunal, opposing counsel raises 2 main points in their rebuttal. The first is that we are inconsistent in relying on the relationship between Mr. Chandra and Ms. Bupati. However, Respondent's position is not inconsistent at all. We do not dispute that Mr. Chandra and Ms. Bupati had a previous relationship. Who did not have a previous relationship is the Respondent and the Claimant. This is uncontested on the facts and can be found on page 48 of the record at paragraph 3. The second point that the Claimant relies on is is that there was an industry usage of using an industry-specific arbitration clause, and we fully agree with this. And this is the reason why Mr. Party was misinformed and thought that the industry-specific clause was to apply. Now, even knowing of this usage and knowing of this impression, Claimant did nothing to correct it, and rather left Mr. Party with such a misunderstanding. This simply cannot amount to a reasonable opportunity to take notice of the terms. Thank you.
Members of the tribunal, opposing counsel argues that there is nothing on the record to show that parties intended for Mediterranean law to also govern the arbitration agreement. However, this is not parties' intention at present. The tribunal will see on page 32 of the record that the pre-2016 clause did not contain a choice of law term. However, Claimant has deliberately inserted the contract law term within the arbitration clause on the bottom half of page 32. By doing so, they deliberately intended for the contract law to also apply to the arbitration clause. Similarly, from Respondent's perspective, they had not known of the existence and the contents of this clause at all. What they did know is Claimant informing them that Mediterranean law would be the law of the contract. They had an expectation that this law would govern all terms in relation to the contract. Ultimately, both parties had a common intention for Mediterranean law to apply to the whole contract, including the arbitration clause. This concludes the case for Respondent. Thank you.
Thank you very much. Just say, I'm sure other colleagues would say, just quickly, heartiest congratulations to all councils. You did an excellent job. Very interesting argument for us. I think you've excelled. Thank you very much, all of you. Well done. So my colleagues will just have some quick words to say before we break.
Mr. President, you allow me, or if we are too much of a time already.
I think we are we're very flexible with the time, I think because it's a final, but
okay, it's a final question to both sides. Just choose who wants to go, if you of the two students wants to take it. I'm still troubled regarding the jurisdiction of this tribunal. I understand that Claimant argues we do have an arbitration clause which has been incorporated and would point to the Nubian law to be applicable in the general terms. And I do understand that Respondent says the tribunal does not have jurisdiction because there is no arbitration agreement between the parties. Now, may I please turn the parties' attention to Article 7 of the contract, and there, the very last sentence and the very last part of the sentence, where it says that any monies due by either party to the other shall be settled, and if not settled, a dispute shall be deemed to have arisen which may be referred to arbitration. And I do wonder, what implication does this wording of the very contract have to both parties' positions on jurisdiction? Maybe Claimant to go first in answering that question.
Thank you for the question, Madam Arbitrator. I would assume that perhaps the response may be the same between the parties, and that is that if a contract has been concluded, and in fact if this is the contract, then this is an arbitration agreement between the parties. But we also concede that this arbitration agreement, as contained in clause 7 of this contract, is not relevant to the present dispute, as the scope of this particular agreement is not relevant to the issues of the formation of the contract. And so So whilst this would appear to be an arbitration agreement between the parties as regards the non-payment of invoices, we would not rely upon it in order for this tribunal to have jurisdiction for the present issue. Instead, the source of the arbitration agreement that we rely upon is in the substance of the Article 9 arbitration clause.
Yes.
Yes, we fully agree with Claimant's position that this is an arbitration agreement, but only with respect to payment of monies for this clause and not to the present dispute, which is about the formation of the contract in general. Thank you.
Thank you, Mr. Chair. Nothing to add but to congratulate both counsel for their very professional presentation and for assisting the tribunal in determining these issues. Thank you.
All right, thank you very much, counsel. Well done. And just give us a little bit of time to. Thank you.
Thank you very much to the judges, and thanks heaps for the great round to our counterparts in Singapore.
Good luck to our counterparts.
And to the opposing side as well. Thank you.
Thank you.
As the tribunal retires to deliberate, we ask the two teams, the two finalist teams, to make sure your microphones are mute and turn off your videos and stay with us in the Zoom meeting. And we'll ask you to turn on again when the tribunal returns to announce their decision. After a message from our sponsor, we will proceed with the awards for Best Memoranda, for the Claimant and Respondent, and for the Best Oralist. We also have an award for the Star Arbitrator and a comment about the spirit of the award this year. By then, we hope that the tribunal will be ready to announce their decision, and we will ask to see them and hear the result. We're all waiting for it. At that point, we'll ask the tribunal and the teams to turn on their videos. The certificates will be sent electronically this week, as well as the award certificates, and you will also receive comments on your memoranda and your scores and standings in the competition. So please now listen to a message from our platinum sponsor, the Shanghai Arbitration Commission.
Ladies and gentlemen, dear friends, greetings from a bronze-mint and breezy Shanghai. First and foremost, on behalf of the Shanghai Arbitration Commission, one of the event sponsors, please allow me to extend our most sincere congratulations to the hosts and organizers for another successful Moot, and to all participants for your outstanding performance in the 19th Vice East Moot. This year witnessed the third year of the humanity's battle against COVID-19. Even when in-person communication is more or less compromised, I'm glad to see that 140 teams have registered for this year's Moot. Each participant displayed teamwork, professionalism, and great passion for international arbitration. As someone who has dedicated herself to arbitration for more than 3 decades, I have had the honor of working with many elite professionals who used to be mooters, and can't wait to see that after the 19th Moot, a new group of young stars empowered by Moot will rise and shine. As a matter of fact, Shanghai Arbitration Commission, referred as SHAC, has constantly supported events like the Vice East Moot. SHAC was the host to the first Moot Shanghai in 2011, a pre-Moot to Vice East and Vice Moot, and is also the organizer to the 12th Moot Shanghai this year. In 2022, 56 teams from 19 countries and regions have registered for the event, and have conducted more than 100 rounds of fierce competition. Among the alumnus of this Moot and Moot Shanghai, many have become the backbone of the international arbitration, including Dr. Fan Mingchao, who is now our Executive Vice President. The value of Moot in cultivating legal professionals have been fully demonstrated, and I believe this value is created through the skill-honing debates, wide connections, and an integrated platform connects like-minded people across the globe. This important lesson is now one of the guiding principles of SHAC's talent cultivation missions. At SHAC, we not only help organize events like this East Moot, we have established a SHAC Academy which offers a complete series of training modules, from fundamentals of legal thinking to specialized skills in international arbitration, and from the perspective of globalization as well as digitalization. We sincerely believe that with joint efforts made by SHAC and their players in the dispute resolution community, including holding international arbitration competitions, seminars, training sessions, and other exciting events, we will be able to promote the arbitration community to a more prominent standard. In turn, the vibrant community will nurture talents just like you to become the backbone of the future. Ladies and gentlemen, the world is changing at an unprecedented pace, and international rule of law is changing as a result. It is not at all bold to say that this is a time in need of legal talents who possesses solid knowledge, a group vision, an open mind, and a dedication to the field of dispute resolution. It is neither too bold to say that if the above description fits your profile, now will also be a prime time for you. As an arbitration institution striving to serve the world, SHAC welcomes talents from all corners of the globe. We look forward to working with you in future events, especially in offline events when situation permits. Spring has arrived in Shanghai, a season full of hope for a better future. I wish you all a promising future starting from this successful Moot in the lovely spring of 2022. Thank you.
This week, and particularly this day, is the climax to 6 months of work. Very hard work by the teams and all of their supporters, the people supporting them financially, supporting them with coaching, with encouragement, their friends and relatives who don't see them for months on end. And it's a wonderful week for us. It's a wonderful week for the people who will win the awards, of course. We don't seem to notice quite as much what goes on behind the scenes because it's not done this week, it's done in private at home, and that is the preparation of the written part of this competition. The written part is just as important as the oral part, even though it's largely invisible. And that's why we have separate awards for the best claimant and the best respondents memorandum. So I'm going to ask that the David Hunter Award be presented by our arbitrator Dalma Demeter, who's coming in from Australia. And she will read the names of the award winners and honorable mentions for the best claimants memorandum. Dalma?
Good afternoon or good morning, wherever you are. My name is Dr. Dalma Demeter, and I will be presenting you the awards for the best memoranda for claimant from sunny Australia. I'll start with the honorable mentions. Honorable mentions this year were awarded to Albert Ludwig Universität Freiburg, Australian Catholic University, Charles University, Eberhard Karls University Tübingen, Faculty of Law, the University of Hong Kong, Georgetown University Law Center, Guangdong University of Foreign Studies, Gujarat National Law University, Heidelberg University, Humboldt Universität zu Berlin, Leibniz University of Hanover, Maharashtra National Law University Mumbai, Nalsar University of Law, National Law School of India University, National Law University Jodhpur, School of Law Christ deemed to be University Bangalore, Singapore Management University, Symbiosis Law School Pune, the University of Texas School of Law, the West Bengal National University of Juridical Sciences, University of Bremen, University of Frankfurt am Main, University of Göttingen, University of Mannheim, and Westfälische Wilhelms Universität Münster. These were all the honorable mentions. Congratulations to you all. Now, the second runner-up this year is the Chinese University of Hong Kong. The first runner-up is University of Zurich, and the winner of the David Hunter Award for the Best Memorandum for Claimant at the 19th Vice East Moot is Ludwig Maximilians Universität München. Congratulations again.
The Fali Nariman Award for the Best Respondent is to be presented by Jagmeet Makar, one of our arbitrators. It goes to the team with the memorandum in response, and there will be honorable mentions plus the winners.
Ladies and gentlemen, Fali Nariman Awards for Respondent Memoranda, honorable mentions Bucerius Law School, Christian Albrechts Universitat zu Kiel, Roshisha University Faculty of Law, University of Oxford, Fordham University School of Law, Gujarat National Law University, Humboldt Universitat zu Berlin, Jagiellonian University, Leibniz University of Hanover, London School of Economics and Political Science, Ludwig Maximilian Universitat München, Maharashtra National Law University Mumbai, Monash University, Nalsar University of Law, National Law University Delhi, National Law University Jodhpur, Royal Institute of Colombo, Singapore Management University, Symbiosis Law School Hyderabad, the University of Texas School of Law, the West Bengal National University of Juridical Sciences, Universitat de Chile, University of Bucharest, University of Chinese Academy of Social Sciences, University of Frankfurt am Main, University of Göttingen, University of Mannheim, University of Zurich. These were the honorable mentions. Congratulations to you all. Ladies and gentlemen, now we have the second runners-up, Albert Ludwigs Universitat Freiburg. And we have the first runners-up, University of Vienna. And the winner is the Heidelberg University. Congratulations to all the honorable mentions, second runners-up, first runner-up, and the winner.
Next on our list is the Neil Kaplan Award for the Best Oralist. To be eligible for this award, an oralist must plead on behalf of both sides, both claimant and respondent. And at this point, I will ask Neil Kaplan to join us from Melbourne to announce the honorable mentions and the winners of the prize. Thank you.
Thank you very much, Louise, and hello everybody, and welcome and welcome to Melbourne. I hope you enjoyed the experience, and I hope you look back on it as a major career-enhancing experience. I'm going to read out the honourable mentions first, and then the runners-up, and then the winner. But please, there's a long list. Please forgive me if I mispronounce your names in any way, but I'm sure you'll recognize that I mean you if you recognize it. So, the honorable mentions are Fu Shan Chong of the National University of Singapore, Jin Yao Su of Peking University, Ling Song Zheng, East China University of Political Science and Law, Julia Schultz, Bucharest Law School, Mudit Dami, Monash University, Lin Tinawi, Eberhard Karl University, Tübingen, Brini Rath, Monash University, Elizabeth Wee, Singapore Management University, Fen Ying Guao, University of International Business and Economics, Helen Steiner, Ludwig Maximilian Universität München, Daniel Bourgeau, Loyola University Chicago School of Law, Jan Laurent Mellinger, University of Mannheim, Yulin Yang, East China University of Political Science and Law, Riet Varma, University of Amsterdam, Dawn Wee, Singapore Management University, Clara Francisca Schreiter, Albert Ludwigs University Freiburg, Austin Eigen, the John Marshall Law School, Vidya Lakshmi Singanathan, National University of Singapore, Moritz Rotter, Ludwig Maximilian University München, Vidi Damani, the National Law University of Jodhpur, Noemi Simon, Heidelberg University, Ashley Tang, Tsinghua University, Shashvat Chandra, National Law University of Delhi, Kaiser Heinrich Maki, University of Helsinki, Joachim Straub, University of Mannheim, Min Elaine Ren, the Chinese University of Hong Kong, Sophie Staron, University of Mannheim, Sin Hee Pan, Fordham University School of Law, Walter Maj Vidmar, University of Ljubljana, Quan Pu Sripui Paul Law, Faculty of Law, University of Hong Kong, Shaja Marinchek, University of Ljubljana, Raoul Sievers, Humboldt University, Berlin, Wenxiu Tsai, National Yangming Chiao Tung University School of Law, Anastasia Petralis, Monash University, Yizhen Lang, University of International Business and Economics, Sen Tao Li, Wuhan University, Jessica Lundberg, University of Washington Law School, Yen Guo Alan Sham, the Chinese University of Hong Kong, Justus Dirks, Westfälische Wilhelm und University of Munster, Eleanor Cheng, Qingzhou University, Eleanor Stegman, Heidelberg University, Emma Prabhataratna, Royal University, Royal Institute of Colombo, Rachel Walters, University of Cincinnati College of Law, Kai Tik Ao Yeung, Faculty of Law, the University of Hong Kong, and Stefan Endeward, the Bucharest Law School. Congratulations to all of you. The second runner-up is Florian Illner, Albert Ludwig University, Freiburg. The first runner-up is Luis del Rosario, Fordham University School of Law. And the winner is Ida Paulak, Westfälische Wilhelm University, Munster. Congratulations to all of you. Well done.
This week would not be possible without the incredible work that has been contributed by our arbitrators, and to thank them as a group, but also to set out a couple of very important individuals. I'd like Shirley Tung to come and make the award for the star arbitrators for this year.
Hello. So I'm a little bit shorter than Louise, so hopefully you'll see me in between Constance and the flowers. I gotta go this way a little. Hopefully you can also hear me. Apologies, we have a lot of IT around us, but we've been informed by now you can hear us. So we are very grateful for, again, as Louise said, all of our arbitrators. For the students out there, you don't know how much work these arbitrators have put in. Not only have they also read the problem, they have made themselves available for you around the clock. And we wish to thank, again, as Louise mentioned, all of our arbitrators. We can't give all of you Star Arbitrator Awards, but all of you are stars in our eyes, and I'm sure in the students' eyes. We do have two particular arbitrators that we would like to give the Star Arbitrator Award for 2021, 2022, 19th Vis East. The first one would be Ms. Daria Durlu Gusumar. Daria, I'm sorry, I know I just chopped up your last name. For all of you out there, Daria had arbitrated in the general rounds, 12 rounds. She was up at all hours of the day because she was in Turkey, but you never would have known it because she was in pretty much every single round. Our second star arbitrator was very close in the number of rounds. He arbitrated 11 rounds in the general rounds and also was up at all the odd hours, Mr. Paul Huck. Thank you both very much. You are longtime arbitrators, and we look forward to seeing you back again next year.
Applause, applause, applause. Now this is the point where normally we would have the announcement of the Spirit of the Moot. The Spirit of the Moot Award is presented each year to the team that has overcome the greatest obstacles in order to participate this year. And this year there will be no award for the Spirit of the Moot. Instead, we want to take a moment to reflect on the absence of the teams from Myanmar, whose internet has been shut down by a repressive military government, and of course the teams from Ukraine, who are busy fighting for their freedom and for the right to live under the law and by the law. So I'd like you to observe a moment's silence, please, to acknowledge those teams and to hope that they will be with us in person next year. Thank you. And with that, I believe the time has come to ask the Tribunal if they are ready with their decision. I understand that that is the case, and I would ask the teams first, both Monash and Singapore Management University, to put on your videos, if you haven't already done so. Do we have them? We have both teams. Then please invite the Tribunal back to this room for their decision. Mr. Chair?
Can I be heard? Yeah? Loud and clear? Alright, it's always difficult to make this type of announcements, but anyway, just to let everybody know that our decision was unanimous. And the winner of this, the final round, is Singapore Management University. And well done to all of you, both teams, did very well. There's only going to be 1 minute, so there you go. Thank you very much.
So it's official, the winner of the 19th Moot is Singapore Management.
Thank you very much, and thank you to the opposing team for the excellent round.
Yes, congratulations.
Congratulations.
Thank you very much.
So that's it. Singapore Management University takes the Eric Bergson Award for the prevailing team in the 19th Vis East Moot. Should we leave another 15 seconds or so for the screaming and the applause that we can all hear in our minds? Well, in that case, I'll ask Sherlyn to come back at this moment and talk to you for a moment about the organization which will make this Moot last a long time for many of you.
Thought you guys got rid of me so fast. Didn't realize I was coming back already. Okay, all of you by now should know, after a week long of participating in the Vis East Moot, 8 months long of participating in pre-moots, drafting memorandas, watching webinars, taking part in all of these camaraderie events, that there is an official association that brings together all of the alums of the Vis Moot Vienna and the Vis East Hong Kong. And that again is the Moot Alumni Association. The Moot Alumni Association, in case those of you don't remember from what I said on our opening ceremonies, is a nonprofit organization that was established in the third Vis Moot Vienna, and it's comprised of academics, students, and practitioners, all of whom not only have an interest in the Vis Moots, but also who have an interest in the international arbitration, as well as international trade law. Now, as I always repeat, and I always like to say this after Chris Key told us last year, the MAA should technically have 30,000 plus alumni officially in our records. We don't. So I hope for those of you out there who are past, present, and future Mooties, you go sign up. But the MAA does have officially over 5,000 members. And again, in the last years, we've expanded tremendously to where we now have a core team of over 50 individuals who work hard pro bono, all in their own time, to put together the various MAA events and MAA projects. For example, we've got the China Project, the Vinda Bono Journal, various conferences, webinars, and seminars. We have regional representatives who promote the MAA, but not just the MAA, but also international, again, trade law and arbitration. Now, we invite you to join our Moot family. Of course, unofficially, you already are a part of the Moot family. We would like for you to make it official. So for more details, please look us up on www.maa.net. Please also look us up on our various social media accounts. I'm not going to repeat them because I tend to get them wrong, but you'll find us very easily. We're very much looking forward to seeing you also in Vienna, whether it be virtual or at one of the established travel bubbles, social bubbles. We have a week full of events leading into the Vis Vienna Moot. We've got another series of our GIA, Generations in Arbitration Conference, as well as our CISG conference. We've got 4 amazing panels where they will talk about, obviously, relevant issues in relation to the Moot, but also hot topics in arbitration and trade law. We've got 2 fireside chats, one with Patricia Natal, one of the directors of Vis Vienna, and the other with my favorite CISG guy, Ulrich Schroeder. So please tune in for that. I'm going to get in trouble for that. Tune in, sign up. We hope to see you there. For those of you who are in Vienna, we have managed to arrange deals with the former Moot Bar. For reasons that all of you lawyers and soon-to-be lawyers understand, this will not be an official MAA event. You will assume all risk if you participate. But if you are in Vienna in person, there is the Au Gazelle that will again be offering discounted drinks and bottle service to Mooties who show up. Thank you again. Welcome to the family, and we hope to see you soon.
So hoping that this experience will continue for you, and knowing that it will because of what you've learned in doing all that you had to do to get here, it's time to say goodbye, almost. But before doing that, I need to thank a number of people who've been just incredibly supportive to us. The arbitrators, of course, we've already mentioned you, but we can't mention you enough. You've just given so tirelessly. It's been wonderful. We've had more arbitrators this year than ever, and we've used you as much as we possibly could, and thank you again. To the coaches whose passion and dedication have helped their teams get here and do so well. To our sponsors, especially our platinum sponsors, SHIC and the Arbitration Center. To our patrons for their lasting commitment financially to us. To Ibrahim, who has provided wonderful technical service via their virtual platform, the ADR platform that they have created here in Hong Kong. The host managers who made sure that the technical moves back and forth from the hearing rooms were handled smoothly and people knew where they should be and when. The Department of Justice for its support of the virtual VIS East and for the VIS East Moot year-round in Hong Kong. To the team, the VIS East team, our General Manager, Lynn Thorburn, IT and social media, Maricel, our members and our board of directors, and especially our new Deputy Director, Sherlyn Tung, who's also a member of the board. In conclusion, on behalf of the VIS Moot organizers, the foundation, and all our supporters, and everyone involved with the Moot, I congratulate the winners of the Moot, the Singapore Management University, but also the finalists, Monash University, who made them work so hard to get there. And I congratulate all of you teams for your hard work and remind you that, as Eric Bergsten has always said, at the Moot, every team wins. And with that, I declare the 19th VIS East Moot officially closed.
We're being a brat. It is not officially closed because Louise can never thank herself, and she shouldn't have to, and she should not, because we are here to thank her for everyone out there as well as the administration itself. Louise puts in so much time and effort in making sure that things run as smooth as possible. Obviously, you can see it's a full week of madness, but we always make it here. We always find a winner, and we always have wonderful weeks of events, of memories. So, without further ado, Ms. Lynn Thorburn and Ms. Maricel Somerville are going to join me in thanking Louise with everyone in the audience, and hopefully she enjoys what we've given her today. Thank you.
Oh, I will enjoy it, yes. That's beautiful. Thank you very, very much.
Now you can close.
Wait, just wait. Thank you very much.
Notice the masks. We are socially compliant. We're putting it on.
And I'm not breathing on anybody.
Thanks, picture. Very good. Okay, now we leave you be.
Thank you. So with that, I'll start again. I declare the 19th VIS East Moot, the third virtual VIS East, closed officially, and invite you to join us here in Hong Kong for number 20, live and in person.